Hello, everybody. Welcome. Welcome to week 3 of It's Your Estate. Today we will be doing the Planning for Incapacity session. My name is Trevor Murphy. I'll be filling in for Dawn as a host today. And today we have as one of our charitable sponsors the Susie Q Center in Laguna Beach. And so I'm going to turn it over to Pete to introduce Nadia. And I'm going to share my screen.
Okay. Hi, hello, Nadia. How are you doing this morning?
I'm doing very well. It's good to see you.
Good to see you. Nadia is the executive director for Laguna Beach Seniors here in Laguna Beach at the Susie Q. And how long have you been the executive director?
Well, I joined the organization a little over 10 years ago. So it's been
10 years.
Yes,
Gosh.
quite fun. Yeah.
Time
I'm a
flies.
senior now, by the way.
I know. I wasn't when you started.
Oh, it was great. You know what? But honestly, when I joined, of course, the previous executive directors had done so much in advancing the organization. But being an old engineer, because I did engineering for 23 years, I just had new ideas. And so during the past 10 years, we've come a long way, and especially with technology. So
well, tell us a little bit about Long Beach, Laguna Beach Seniors, and
Okay.
What is the mission and what do you do, and give us a little background.
Sure. We've been in business as a nonprofit organization since 1975. So this organization was established a long time ago before I joined. Unlike all other senior centers, we are not a part of the city. So we are an independent nonprofit organization. And we used to be, for people who are familiar with Laguna Beach, we used to be in the old Legion Hall. And then
I remember those days.
Yes, back in 2009, we actually moved to this beautiful, gorgeous building called the Susie Q. That's where we are here now. And we offer over 60 programs, classes, and activities to seniors from all the way from 8 o'clock in the morning till 5 o'clock in the afternoon, Monday through Friday. So we also have social services here at the Susie Q, and this is a very important department for us because we pretty much take care of over 1,400 households in Laguna with social services. I established a behavioral health or mental health department when I joined, and we have 5 psychologists working with us. And we are the only senior center in Southern California that offers free therapy to seniors who feel a little down, depressed or isolated. If the family members have moved out and they're not feeling good, they come to us, and together, we work on their well-being. So we're very proud of this program because it attracts some funding from the foundation, from various foundations. And we work hand in hand with Mission Hospital in Laguna Beach, because as you know, hospitals actually every 3 years, they have to do a needs assessment in the community. And this program was created based on the needs assessment that was done by Mission Hospital. So I love this program because it helps so many people. We also provide therapy sessions to the families of the seniors so they can work together in creating a better, experience in life for seniors.
Yeah, one of the things that I do, Nadia, is that anytime I have clients here in Laguna Beach, I have the caregivers take the client to the Susie Q. And yes, it's absolutely wonderful because people need people. They can't be isolated at home.
Yes, absolutely. We also had to think about seniors who are homebound and are not able to come to the Susie Q. So we created a program called Lifelong Laguna, where we actually train volunteers who are able to go into the seniors' home, visit them, do chores, run errands for them, and then keep their company. And it may be as simple as just sitting together, having a cup of coffee and playing cards. So that program is also very successful because what we do is a free home modification assessment. The whole purpose of this program is to make sure that the senior has the needs, their needs are provided for, and that people are not alone or feel lonely. And in case if they're have to move to a skilled nursing facility or assisted living, at least we delay that so they could live at their home for as long as possible and be comfortable.
So one of the things, Nadia, that we always do is we encourage people always to give money so you can fulfill the mission. But one of the things that you do so well is that you bring in the volunteers and have them actually do the work. And I've talked to some of the volunteers, and they get more out of it than the people that they're helping.
Yes, absolutely. It's a volunteer. We have over 65 volunteers, and,
amazing.
And nobody leaves because they really see a meaning and value for what they're doing. And I just wanted to briefly mention that during the pandemic, as many people know, a lot of senior centers closed and went home. But we decided that we're going to transfer all of our programs online. So we spent about 2 weeks, day and night, doing that. And it was very successful in staying connected to seniors. So we probably had every quarter, we had over 4,000 people attending our programs. Wow. For those seniors who were not didn't have devices, we went ahead and purchased some iPads and trained people how to go on Zoom and attend programs. So it's been a very successful, I would say, pandemic time for us, although we all hate this time, and I know that it's created a lot of isolation. But that also brought me to think that now that the doors of the Suzy Q are open, that every in-person class should also be able to, we also should be able to offer it online. So what we call a hybrid. So in order to create the hybrid program, we are equipping all of our classrooms with the state-of-the-art technology. It's a very expensive undertaking, but it was, the money was gifted from a state plan of our late donor, Al Roberts. $100,000 came in, and we were able to have the money to do this so that all of the seniors who attend our programs would continue to do that, whether it's from the comfort of their home or whether they like to come to the senior center. So, going forward, we are building our plan giving program. And in 2019, we created a campaign with a goal of 5 million. And I'm glad to report that as of October 1st of this year, we have 3.8 million in commitments, and we have 1.2 million to go. So I would really be, thankful for people who include us in their state gifts and in their legacy. It's those type of gifts that really make your favorite nonprofit organization strong. So I'm going to stop here and ready to answer any questions that there.
Yeah, Nadia. The Suzy Q is open for all programming. So if anyone wants to find out the program, just give Suzy Q a call.
Yes, absolutely, absolutely.
Okay.
Yes. And you can Google us, and we're all over the internet. So our phone numbers are there, email addresses. I'm available. My door is open to everyone.
Okay. So, and you have a therapist on staff, is that correct?
We have 5 therapists that work with us on a schedule, and okay. We'll be happy to schedule anyone who needs help. And we also have 8 support groups going on, and those are also being facilitated by professional staff.
Okay. Thank you, Nadia. Really appreciate it. We'll see you at 3 o'clock today. We're going to have our It's Your Money session from 3 to 4:30.
All right. Thank you.
Thank you. Take care. Right. Bye-bye.
Bye.
All right. Let's go to our art program. Jennifer, come on screen.
All
there
right.
She is.
I thought you were going to say, come on down.
Yeah.
Okay.
I know. Price is Right. I think
I
that
know,
was
right?
the line, right?
Yeah. Okay, so just so if everyone that's here already, Jennifer has prepared a poll that she'd like to do before we start the session. So what
Well,
I
let's introduce this session first.
you want to introduce, you want to do the ask first?
No, I just introduced. Jennifer is an attorney, and she's going to be, the topic today is going to be planning for incapacity. So let's do the survey, and then we'll introduce her and using the ask first form.
Okay, so we haven't done one yet, guys. So this one, I'm going to launch it, and then right on your screen, super easy questions to answer. And then when I feel everyone's finished, we'll move on to the next poll. Okay, so go ahead and start answering those questions. Yeah.
So do you get a feedback as to kind of the number of people who have responded?
Yeah, I'm supposed to, although nobody's responding. Well, at least it's saying no one's participating. Come on, guys, participate. But that could be maybe when I end the poll, it will.
There's a question.
Yeah.
Submit button not working.
Oh, okay. Hang on.
Thank you for that feedback.
Let me see if that's something to do with my settings, but that shouldn't. Okay.
Right. Let's see. There's no option for don't know anyone incapacitated. Well, that's good if you don't know anyone. Then no answer then.
Okay, hang on. Maybe it's on the participant side.
And should I do a drum roll?
Oh, wait, no, they're starting to come in now.
Oh, good. Okay.
Okay, yeah. So it's strange. Some people it's working, I guess others it's not, but.
Okay, we'll get a kind of a sample then, those two, the responses.
Okay.
But give it another minute.
Yeah.
These are not easy answers.
No, they're 10 questions. There's like 35 questions.
Jennifer, you're putting our audience through some work.
Well, some of them are just, was your choice for, 3 and 4 the same? So some of them aren't as difficult as they seem. Trevor, when this poll is done, don't do the next one. That's plenty. And frankly, if you have 10 answers, that suffices. It's just sort of to talk through the issues.
Yeah, I've got some. So I'll end the poll. And then I'll share the results.
Okay. So do we do the results now or should we introduce Jennifer first?
Yeah, well, introduce me.
Okay. Otherwise, these will go because these are in the middle.
No, I just need the answers. It's just an exercise.
Oh, okay.
So, yeah. Everybody is saying, let's get on with the show. Let's get on with the show.
So you're getting those answers for you. You can see them, Jennifer?
Yeah, I can.
Okay. All right. Then let me share the screen. Okay. Let me know when when you got all those, Jennifer, then I'll stop sharing the poll.
Oh, just keep sharing the poll. It's fine. I'll just keep it there.
Okay. Okay, so we have the ask first up there.
All right. So let's introduce Jennifer. Master's or other advanced degree. I'm assuming that's your law degree. And your credentials, your Denver Strum College of Law, and a master's in legal and forensic psychology. What is that, Jennifer? Talk to us about that.
So a master's in legal and forensic psychology is to discuss the nexus between the psychology of capacity and competency and brain function And then on the legal side, whether or not you have the required legal capacity. So it's a master's degree that is part psychology and part legal psychology.
Wow, what a background. That's great. How long have you been in the estate planning area as an attorney?
So probate's pretty much all I've ever done. And after I went to school in Denver, I actually stayed home with 3 babies and then went back to work about 10 years ago. So I've been working for about 10 years.
Okay. You're licensed in the state of California, and there's your license number.
Yes.
And then you put your client's interest first. Why don't we scroll down and talk a little bit how you charge for your services?
So it's just legally in general, all attorneys are supposed to provide clients with a legal service agreement if it's going to be anything over $1,000. So if there's ever any kind of interest or any work that I do on behalf of clients, there's usually always a legal service agreement, and it will spell out the scope of the service and then the hourly rate that the attorney pays.
Okay, and so let's say I need a will, a basic estate plan, durable power of attorney, an advanced healthcare directive, and a living trust. I'm married, and I have 4 different major assets. Approximately, what would you charge?
Yeah, I don't do drafting, so I don't know. Yeah, I don't do, well, I used to, but I don't do it anymore. Now I do primarily just when everybody fights and go to court, and I do
so you're in the estate planning litigation area.
Yeah, so I do probate, trust, and conservatorship litigation when it's the pretty complex stuff.
And talk a little bit about that, and what is your hourly rate? What's kind of the average, because people have no clue as to what litigation costs in the probate area. Give us a little bit of an idea of what it takes to go to court.
Yeah, so to answer the first question, if you were to do an estate plan and it was for a married person, I would say that on the most range, somebody's going to end up paying somewhere between $2,000 to $4,000 for an estate plan married couple with all of the bells and whistles and all of the different processes. Having done it long enough and knowing and referring out to people who do this and only that. And I think when you look for someone who is doing estate planning, you want to make sure that you're finding someone who only does estate planning, or maybe primarily only estate planning, because when it's done poorly, you then end up in court. And so when you end up in court, a lot of times what's going on is people are either arguing about how it was written and what it meant, what it was supposed to mean, or someone is in charge and is acting under or on behalf of another person, or a power of attorney or a healthcare directive, and the family members don't like how that one person is doing it. So usually it ends up being sort of mom or dad is older and somebody is taking and helping them with either a power of attorney or healthcare directive and acting on their behalf. And, the other siblings don't like what they're doing or like what they're seeing or feel good about it. And sometimes there really is somebody acting inappropriately. I do a lot of financial elder abuse litigation. Sometimes there really is just sort of a disconnect or a misunderstanding. And really, if you can catch it early on before people start to, it's kind of funny, but I always say, what's the P when there's that story of the princess and the pea? If you can figure out what the actual issue is between the family members who are fighting, it usually goes back a pretty long way and is related to something that has just existed in a family dynamic for a really long time and is just coming out now. In terms of another example, when you have people who are siblings and one is in charge and gets to do things, that sibling rivalry seems to rear its ugly head very often.
Yeah, that's what I see too. So what is your hourly rate?
I charge $375.
And
And I
then,
think when I tell people, when they're going to, and we get a lot of calls like this a lot that say, well, what am I in for? What should I expect? What is litigation going to cost? What's the, circumstances? And to be honest, it's like asking a doctor, how bad is the cancer, without having done any kind of testing, without having opened you up. There's no way to really say.
but it's not cheap.
But it's never cheap. And I will
Yeah.
tell you, first and foremost, when people look at spending that money on doing estate planning, good planning is going to cost you between 2 to 4 usually, maybe more, maybe less, depending upon the number of assets and proceeds. But for the most part, good planning will save you 9,000 exponentially fold, if that even is an accurate term.
Yeah. I usually, when people say, hey, I want to go to court or want to sue my sibling, and it's usually between family members, I usually say, be prepared for 2 to 3 hours of heartache and stress, and spending, if you spend 100,000, don't be surprised.
Right.
So
You wouldn't blink at 100,000. Yeah.
Exactly. It's not something that you want to go. It's kind of like the Midas muffler, you do it now. So good planning takes place. And a lot of it is around the 2 documents that we're going to discuss today. So let's get into the program. Let's get into your outline. You want to go ahead and do that, Trevor? Da-da. And we're going to have we're going to discuss first the durable power of attorney.
Can you see it?
Nope, can't see it yet. Oh, I see. Nope, I can't see it yet. The ask first form is what I see still on the screen. Now I don't see anything.
All right, I got you.
Okay.
How about now?
There we go. Okay. Why don't we scroll down?
Whoa, sorry. Okay.
So Trevor, is there a way to put that result next to it?
Polls. I can share results again.
Okay, that's good. Just so I can see them when we go.
I just don't know if the poll box is obstructing your view, you can minimize it on your screen there.
Yeah, I couldn't move it on mine, so just so you know, so I just minimized it.
Okay. All right.
Okay, Jennifer, it's all yours.
Okay. So before talking about power of attorney and all of the other good documents and so forth, I think it's helpful when we talk about when we plan for any kind of incapacity and dealing with the issue just in general. What you need to look at is when you do an estate plan and you prepare those documents, and essentially they are a trust, a will, power of attorney, and a healthcare directive. And when you talk about a power of attorney, that is someone acting on your behalf for financial questions. When you talk about healthcare directive, that's someone acting as your agent to be able to make decisions regarding your health if you're unable to. So when you look at that, we talk about that in terms of money or person, and money gets called estate under the law in this area, right? So we're talking about money, estate, and or person. And when you authorize someone to act on your behalf under a power of attorney or a healthcare directive, you're saying that you want that person, if you're unable to make decisions in those arenas for yourself, this is the person that you're appointing to act for you in your stead. And one of the biggest issues that comes up for people when they're dealing with this situation a lot of the times is if you've given someone that authority to act on your behalf and you're comatose, it's pretty clear that they should be acting for you. The question is more along the lines of what happens when someone is acting for you And either someone believes what they're doing is not correct, or you're not being protected. And so really, when you look at capacity in general, the big picture issue when we deal with any kind of estate plan and any kind of legal process dealing with it is really, it comes down to the issue of the courts are going to look at, and the world is going to look at, autonomy versus protection, right? People have individual rights and they get to make their own choices. But at the same time, we as a society believe that we should protect the vulnerable and not allow people to be taken advantage of and have things taken from them or abused or whatever. And I think some of that is really, when you look at the issue, if you can look at it in terms of that particular sort of balancing act, it's helpful to understand a lot of times what the court is going to do, what the law says about these things, and then how people try and approach them. And so we don't have to really go through the specifics of the poll. It's more fun when you get to do it in live with buzzers, and then, people get to, and you get to see the numbers pop up in a big thing on the screen. So via virtual, maybe it lost a little of its impact. So we're not going to worry about it, but it is sort of telling, because what ends up happening the majority of the time that we do all of these polls is the first questions are about, do you know anyone with dementia or Alzheimer's, right? And people usually do, right? People usually know someone who has dementia or has Alzheimer's. This one, actually, your poll, and obviously we stopped it when it had 7 people there. So 7 is good, because at least it's not going to be an even number, right? So we're not going to have ties all the way across the board. But at the same time, 7 people is not necessarily indicative of the entirety of the audience. So it is pretty not, I would say, the norm to have people who don't know anyone in this day and age with dementia or Alzheimer's, or have known someone with either. But regardless, we have it basically split so that more people do know people with Alzheimer's or dementia than don't. And then out of those, the question is, how many incapacitated people do you know? And most people answered 1. And it could have been that it was 1 or none. I'm not really sure, right? It's not a perfect one because the answers were changed a little bit. But how many of these incapacitated people are under conservatorship? And everybody put every one of those people was under conservatorship. So either the audience knows a lot of people under conservatorships, or the questions were maybe a little less clear under this circumstance. And I think in person, it's a little bit more, it's a little simpler to tell what is exactly going on. But the basis of it is, when you are talking about, and you can go to the next one past, there we go. So when we're talking about what happens with people when they have a diagnosis and whether or not there are any different issues, most people end up calling people incapacitated, and the reality is that they're not under any kind of a conservatorship when they call them that. It's simply them using the notion or the fact that they do have dementia or Alzheimer's, and then labeling them as incapacitated. And I think it's important for people to understand that under the law, there's a presumption of capacity. So when we look at this issue of if someone has any kind of Alzheimer's or dementia, if you have a power of attorney and you've authorized someone else to act on your behalf, is that person able to take under when you are able to make decisions for yourself? And the reality is that under the law, we are all presumed to have capacity. So you have to actually go through the process and have a judge determine you to be incapacitated before you become incapacitated. And so people need to understand that there's a lot of different levels of choices that you can make before you have all of that legal capacity taken away from you under those circumstances. And so there's a different level or different capacity determinations, basically, that apply to the notion of the kinds of questions that you're being asked to make. So when you talk about a power of attorney and you're talking about someone being able to be in charge and help make choices for you if you want to, or if you appoint them to, we have 2 different kinds, and they're, yeah, Yeah, that's fine. There's two different kinds, and basically those two different kinds are either springing or immediate. You can give that person immediate authority under your power of attorney to act on your behalf, or you can make it so that it's springing, which means it then is only able to be used upon your incapacitation. And again, it's my least favorite word because people use incapacity a million different times, a million different ways, and it's supposed to mean a million different things, but it really only means one thing, and we use it inappropriately. But under most springing powers of attorney, it is incapacity as determined by either one or two doctors usually. Sometimes it can have the language in there that says the incapacity is, determined by the actual new agent.
So Jennifer, so we're talking about the durable power of attorney for finances. That's what
Correct.
You're talking about right now, correct?
Correct.
Okay,
Yes.
and in that document, it gives someone else the power to make financial decisions for you,
Correct.
And
Yes.
then in order to have that legal authority to make that decision, there are two major types. And one is the springing and the other is the immediate.
Correct.
What I am recommending to most people that they, if they're 70 and older, to have an immediate. Because today, to get a medical doctor to state that you suffer from some sort of incapacity is very difficult. So
Correct.
I don't know, what are you seeing out there that, or what do you recommend?
Well, I try and tell people realistically, if you have someone that you trust, you can hand that over today. If you're worried about the people in your world, you need to worry about people in your world. And so you need to be able to put documents in place that really make sense. And so under that circumstance, I think I wouldn't necessarily, I would give them you're asking if I'd say A or B, I would give them choose C. And the reason for that is you need to look at your life and say, where am I at and who are the people in my world? And do I trust them complicit or implicitly, completely 100%? In which case, you never want to give them a hurdle that they have to jump over in any way, shape, or form. You always want it to be immediate.
Yeah.
So,
Trevor, you want to go to the next slide?
if you don't, and this was just a capacity difference between understanding how people talk about legal capacity and mental capacity and the definition of it.
Yeah.
And
go to the
basically
next slide.
that just has something to do with the effects of when you're talking about the incapacity determination.
So if you don't trust it, so Jennifer, what you're basically saying, if you don't trust a person enough to give them an immediate, you should have second thoughts about even naming that particular individual.
Yeah, and I would say it's definitely something that you need to discuss or really just sit down and think about. Who are the people in your world and who do you trust right now? And based on who you trust right now, give those people the immediate authority. If you find yourself in a position where you're thinking, I don't want to have to be able to, I trust them, but I don't want to have to give anybody over immediate authority over me, that's exactly the time you want to give over that authority immediately. Because if you have the ability to make those kind of determinations and understand all that's going on, that means you are well within your right mind, you have complete capacity, and you hand that over to someone. And if they start to do things on your behalf, it will only be at your direction, or they're usurping power that they're not entitled to at that moment, right? So let me explain that to everybody else, which means if you have a power of attorney for finances and you make it an immediate one, all that means is that that person is authorized to act on your behalf if you want them to, at your direction. They're authorized to help you in terms of, hey, can you run down to the bank and sign that for me? And here's what you need. And you have a power of attorney and it's signed, and they can go and act on your behalf at your direction under those circumstances. It can also then be used when you are not fully capacitated and under some inability to make your own choices, then they can continue on acting. But there should be no discrepancy between, would you give them the authority to do that now Because if you're in your right mind and you've given them the authority or the authorization, if it's abused, you take it away, and you know those were the wrong people to appoint. So it kind of is, you can't lose by giving those people that authority now. You find out very quickly if those are friends or foes.
Yes. And Trevor, why don't you go to the next slide? One of the things too is that we always think of the estate planning documents as something during at death. And these two documents are all about while you are living. So some of the statistics that you're seeing on screen shows you the importance of having that durable power of attorney for finances, to have that person in place in the event that you need the individual. The other thing too is that if you do have a medical doctor to say that you have suffered from incapacity, please only have one. I have lots of attorneys are putting in 2 people just because it makes the client feel more comfortable. But it's a real problem out there to get 2 medical doctors today to state that you suffer from some sort of incapacity. And when the time comes that you need help, it means that you need help now. You don't need help 2 weeks from now. So let's go to the next slide.
Hey, Pete, I just wanted to make a point. Someone asked a question, and I'll be happy to answer it. But if you give immediate power to somebody, do you still have the power to handle your own finances?
Of course.
Yeah. The answer is yes. They are not replacing you. They are just put in place to help you and assist you.
Yeah.
So just don't.
And frankly, you can have an immediate power of attorney, and you can put that into place. You can also revoke it at any time under almost any circumstance and create a new one. So that's not an issue in any way, shape, or form if you give it away to someone else. The second one that the revoking of it and giving a new one is pretty common these days. So it is not something you should be afraid of. I would say for most people, you would want to have something in place, even if it's something that at some point you're going to change, because the absence of it in general is what leads to a conservatorship. And that is.
Go to the next slide, Trevor. Keep talking, Jennifer. I'm sorry.
Peter, I don't think my slides match up to anything that you think that they might do, because I'm not sure this is.
I know. I'm reading through your slides, and that's so so that's why I say keep talking, and I'm just giving Trevor a clue to go to the next slide.
Yeah, Trevor, keep going through them. Don't sit on anything, because there's nothing that's gonna.
I'd prefer if Jennifer tells me when.
Okay.
Okay, go to the next slide. Okay, so when we were talking about there's different levels of capacity, when you have a power of attorney and you have someone else who's making the decisions for you, if you don't and you start to lose capacity and people start to become wary or worried about whether or not you have the required ability to take care of yourself and make your own financial decisions, understand the nature and consequences of what it is that you're doing, those are the kinds of things that lead people to take over under a power of attorney. And I shouldn't use the words take over. Let me rephrase that. To begin to act on your behalf more at their own direction versus at your own direction. And I think that taking over terminology is probably what leads people to sort of fear a little bit the fact that they're going to authorize someone else to act on their behalf without making them have to jump through these difficult hoops of the 12 doctors, because you get worried that the second that you give them this, you're going to end up being deprived of all your rights and locked in a closet, and the evil person is going to take and use all your money.
Yeah.
Go ahead.
Yeah. One of the things is that because it's a contractual capacity, banks, financial institutions are very leery of these durable powers of attorney, because if it's fraudulent, then they are held liable for it. So if you have although legally, if it's a 5-year-old durable power of attorney, it should still be valid under the law. However, a lot of institutions will not honor it unless you bring in an attorney. Another thing too is that lots of financial institutions don't like the attorney drafted documents. They want you to complete their own. So when you go into a Bank of America or a Wells Fargo or PERS, they want you to complete their durable power of attorney. That doesn't mean that your own is bad or no good. They just want to make sure that you comply with their institution recommendations. Jennifer, do you have any comments on that?
Yeah, I love that because I make a lot of money off that. I mean, it's illegal, it's wrong, it drives me nuts. The fact that they think those businesses think that they can get away with doing that to people and telling people that they have the right to sort of usurp what they're legally entitled to, it drives me bonkers.
Yes.
So yes, it does happen. B, should it happen? Absolutely not. C, is it legal? Absolutely not.
Yeah.
D, can they make those requirements and claims? No, absolutely not.
Yeah.
So
you got a choice to make. You got to either comply with that institution's recommendations, or you've got to fight City Hall.
Well, I mean, I think not necessarily. The thing is that I think what they do is I think they tell people this is, I mean, they're workers. This is what we want to have happen. It's sort of, their best business practice is to have people come in and everybody use their form. And that's not wrong. They're allowed to do that. It's their business. What becomes wrong is when you are sort of the exception to that rule, and it doesn't necessarily make good sense for you to be signing something now that's new, because something that you already did sign, 6 months ago was perfectly valid, not the least bit questionable, in good faith. Everybody understands it, and it was the right thing to do. And now, because the bank's procedures are required, they're putting you into a different position where now 6 months later, your son is bringing you into the, bank, and you have your daughter on your POA with your attorney that has signed this, and this is your POA that's been in place for the last, 10 years. But now the bank, because of their procedure, your son has brought you into, and I should say your son that just got out of rehab, right, and has had longstanding drug problems, has just brought you into the bank, and the bank is saying, well, we think that you need to use our form to sign a new power of attorney. And well, as long as you're here and you're signing a new one, why don't you just go ahead and put your son on there because he's here, right? So now all of a sudden, that's how we get into issues and end up in litigation, where there was a perfectly good and wonderful and delightful power of attorney. Now we have people who are engaged in the issue of, we have financial elder abuse going on. What's the logistics? Did she have capacity to sign that secondary power of attorney at the bank? Was that appropriate? Should that be void? Does that void the one prior to done at the, right? So I understand where banks are coming from, but I think banks are creating the problem, not solving it.
But please take your durable power of attorney to your financial institution and ask them to put your power of attorney in their file. What does the term durable mean, and why is that so important in the estate planning area?
So durable just refers to the fact that you sign it when you do have capacity, because, Trevor, can you go back one? Yeah. So when you have different levels of capacity, contractual capacity is the highest level. And that's when you're entering into a particular contract or you're creating something like a power of attorney. That requires a real high level of capacity and decision making. And so if that power of attorney that you have just created is when you have the highest level of capacity and you understand everything that's going on, you're in your right mind, all good sound of body, mind, and spirit, you make and create a power of attorney. If you sign that as a durable power of attorney, it means that when you then become incapacitated, it has a continuing duration and is continually durable despite the fact that you have become incapacitated.
So durable means it's good through incapacity.
Correct.
And then should people draft their own durable powers of attorney, or
only if they want to do surgery on themselves by themselves too, right? If you want to do your own surgery, then by all means do your own power of attorney.
Okay, it's
if
a
you
powerful document. It's used to people always kind of confuse what are the powers under a trust as a successor trustee, and why would you need a durable power if you already have a trust?
So imagine that you have two separate hats. One is the trust and everything that goes into the trust, and whoever is acting on behalf of the trust is called the trustee. Whoever creates the trust is the trustor. So the trustor has one kind of hat. They can be the initial trustee. They can hand that power of trustee management, of managing the trust, over to anyone else that they want. That's a different colored hat, right? So that particular hat is the trustee wears that. That trustee is in charge of any and all of the assets that are actually titled in the trust. If something is not in the trust, then a power of attorney could act on behalf of it. But they are two distinct issues and they need to be understood. If it's in the trust, the trustee handles it. If it's outside the trust, the power of attorney would handle it, or the original person, and that's it.
Yeah, so if I have to handle and talk to Cox Communications, Cox is not an asset in the trust. And so I have to show Cox my durable power of attorney to act on behalf of my client. Edison, same thing. Hospital bill, IRA accounts. I mean, it goes on. It's all things that are assets that are outside of the trust in the individual's name. And does it specifically have to state in that document that I have the power to manage an IRA, or I talk a little bit about why it's so important to get to an attorney's office to draft these documents.
Right. So there's a couple of different reasons. And I was being a little flip when I said, yeah, if you want to do surgery on yourself. But the reason is it seems very simple to do a power of attorney. They have statutory ones available. Worst case scenario, I would say, if you're not going to do anything at all, then do one yourself, right? Off of the statutory version, the uniform version online that you can get free at the library, right? That's, if you can't do anything else, at least do that, because that's one step better than nothing. But it is pretty close to nothing because it's not great. And the reason that it's not great is because when you do a power of attorney and you do it together with an attorney as a part of an actual estate plan, they work together and they need to work together. The power of attorney needs to be able to talk to the trust, and the trust needs to be able to talk to the power of attorney. And the only way that you can do that and have that reciprocal language in there is if an attorney actually drafts it. And why that's important is not everything is automatically in your trust, right? So if you have a trust and your trustee is allowed to handle any and all of those things, what happens if you take your house out of the trust to refinance it, and before you get to put it back in, COVID happens, right? And then it gets harder to get into the bank, or we go back into a shutdown for a little bit and you can't get your documents transferred back in to go get a notary to get it done or recorded. And now all of a sudden your house is outside of your trust, right? Well, your power of attorney would have to then act, if you were unable to for yourself, act and be able to put the house inside of the trust and sign that deed for you, right? So you need both things to work together, and you need both of them to be able to take care of what is in a trust and what's outside of a trust.
So
it's not a one size fits all.
Yeah, one of the things that we discussed last week, the importance of understanding how you hold title. But the other thing is that who would you recommend? Talk a little bit about who should you name as your attorney in fact,
Right.
or
My suggestion to people is always keep your money side the same in the same order, and keep your health side in the same order. And they don't have to be, equal parts. You can have different people be in charge of your money than you have for your health. But whoever's in charge of your power of attorney as your first agent should also be your first agent for your trust as your trustee. So your successors should line up as first choice for immediate people next, Peter Kote over here, then Peter Kote better be over here on the power of attorney, because what you don't want to have happen is have Trevor be your successor trustee and Peter Kote be your successor or your immediate power of attorney.
What attributes should that person have? Where should they be located? Or does it matter in this modern age of communication?
Yeah, I would say for the most part, it's more flexible than it used to be. If it's something, we can get bill paid, we can get a lot of things done that doesn't necessarily have to be someone right next door, but it shouldn't be somebody in Egypt either, because, there's got to be a healthy blend there. It might be somebody who's, up in Santa Barbara, but they can come down here, and they can come down here twice a month or something like that, right? That's better than having someone that you really don't trust right next door. On the money side, on the health side, I think it's a little bit different. It depends on what sort of state you're in. If you're older and, more vulnerable at that point, you might want someone who's closer. But I would say no matter what, if it's not somebody that you trust, and you don't trust anybody at this point, and that's not a bad thing, right? I know how hard this job is to do for trustees. I know what's required of them. I love my kids, but my kids will never be my trustees, right? And they're good, smart kids, and I trust them with everything. I would give them a different position. I would let them be sort of the oversight person to take care of and watch that independent trustee. But my trustees will always be fiduciaries, like professional fiduciaries who do this for a living. And my kids will be my healthcare agents.
Okay.
And that's just the way it is.
Yeah. So in selecting somebody, many individuals just go to family members, say, no matter, and they think it's a position of honor.
Yeah, I say if you don't like those family members, then by all means name them. Because if you hate them, then that's the perfect payback.
But it's an administrative.
It is a hard, thankless. It's an administrative job.
Chore. Yeah, exactly.
Yeah.
So it's paying bills. It's keeping track of your checking account. It's watching your IRA. So you have to pick someone who has some business skills.
Right. And so to me, it's why would you leave it to the, my kids are brilliant. I'm not saying that I wouldn't give them everything. I would give them
the next slide, please.
I would give them the position of being able to overlook and watch and supervise that process, and have some,
what happened?
Ability to do something on that end.
Trevor, the outline disappeared.
Yeah. Can you go back one, Trevor? Go up to this one right here. So
Okay.
This is just one of the other, small issues that relate, is when you give power to individuals who really don't know what they're doing. Sometimes it starts off as just a small problem that builds. Sometimes it's people just take a little bit here and a little bit there, and it seems okay and it's not that big of a deal. But I would say for the most part, I do a lot of work with, I volunteer for FAST, which is Financial Abuse Specialist Team, through Council on Aging, and have for years. And, one of the biggest issues that come up with elder abuse and financial side is the only side that I deal with. But it really is because when you hand those agencies over to someone that is a family member, and you're picking one kid versus another kid, it really does tend to start a lot of these issues that don't need to get bigger, right? So that's sort of just my only touch.
Yeah, you got to look at your kids objectively, and remember that the abuse, it doesn't come from the professional fiduciary or the caregiver. most of the vast majority of use comes from family members. And so
I think it's as high as like 90%, 85
Yeah.
to 90%.
So you just got to look at your family objectively. Okay. This is about, it's your estate. It's not your kid's estate. And your kid's estate, it doesn't become their estate until you die or unless you make a gift to them. So look at them objectively. Let's go to the next slide and stay in charge. You're going to be a lot happier. Undue influence is huge. So from phone calls to when you walk into a bank, get sold an annuity, to a neighbor or a family member, I'm sure, Jennifer, undue influence is one of the biggest issues for you in the courtroom.
Yeah, I mean, it's the hardest one for anybody to be able to really definitively pick up. It's the hardest one to prove. It's the hardest one to recognize, right? So when it's happening to you, it's hard to figure out. And when you're trying to prove it that someone else did it, it's hard to prove it. It's really sort of the most sort of murkiest issue.
Yeah, and so the important part about this is that you need to prepare this document today. It's
Right.
one of the most important documents that you need to complete. Let's go to the next slide.
But I would say it's one of the most that you need to complete, but you really do need to do it as a part of a plan, because the plan needs to work together in order for it to be cohesive. And that's just from the litigation side. I'd rather have somebody have a power of attorney than none, but a better version. And the ones that we rarely have to go into court on are the ones where there is a power of attorney and a trust like actually drafted by a good estate planning attorney, and they reciprocate and talk to each other.
Yeah, Jennifer, do you think it's appropriate today, right now, to begin the discussion and transfer it from the durable power of attorney for finances to the advanced healthcare directive? Or do you have more slides that you want to go through on the durable power?
No, that's fine.
Okay.
There's just so you know, there's 30 minutes left, guys.
Okay, good. The advanced healthcare directive. Well, what is it and why is it important?
So the healthcare directive is basically just for the healthcare agents to be able to make decisions for someone when they're unable to make decisions for themselves. So just understand that when you go, if you go into the hospital, regardless of whether or not you have a healthcare directive, let's say that you do, and you have appointed your agent is your, let's not have it be your spouse because that's too easy, but let's have it be your one of your kids. One of your 4 kids is your agent. And you go into the hospital and they're deciding what needs to happen. They go through everything. The doctors talk to you. The doctors will go to extraordinary lengths to be able to have you be the person to make your own decisions for any and everything that is possible. So they will get so that people are, can you squeeze my finger and let me know yes or no, right? They will ask you to blink. They will ask for anything under the sun. So understand that when you have a healthcare directive, it is, you get to make any and all decisions possible unless you completely cannot. And they really do exhaust that, completely cannot.
Yeah.
So I think that usually ends up making people feel better about that.
Yeah, I was just in the hospital with a 94-year-old, and the doctor was in the emergency room, and the doctor was asked, who is the president? What state are you in? What's your birth date? Wanting to make sure that the individual was understanding what the medical doctor was stating to her. And so, and looking for, or that she has capacity and understanding what he was saying. What I find though is that when people complete the advanced healthcare directive, there's like 2 choices that they make. Extraordinary care to keep me alive, or, don't take any extraordinary care. What does that mean in the medical world?
Yeah, I mean, I think it means a little less than people believe it means, because realistically, it's the dichotomy between the law and medicine. They don't speak the same language and they don't work in the same ways. So that's sort of, issue number one when we talk about some of these things from different perspectives. But from the medical side, they're going to do everything that they reasonably can, no matter what, right? The question really becomes, once they have exhausted that, then they're going to ask you, is there Herculean means that you want us to undertake and try and continue to resuscitate and continue to resuscitate and continue? Or once we have ability to say, we're just going to keep doing this and it's going to just continue on a loop, but we're not going to change anything, they're then going to let you make that decision. And so I think people kind of in their head fear that notion of, if I don't sort of decide myself what that's going to be, I don't necessarily want to hand that over and give anybody else the ability to make those decisions. I think sometimes people get afraid to even create these documents because they're scared by what it is that they're handing over to another person.
Jennifer, my mother said, if I complete this form, I'm going to die.
Yeah. Right. And it's so far from that. It's just something to ensure, whichever way you feel about it, that's what is actually honored. And if you put it in writing, then other people aren't going to decide that, and or the courts aren't going to decide that for you.
Yeah.
And I think that's the important part.
And your comment about the legal and the medical field not coming together is so true, because what is extra? I was in an emergency room with a client, and she was on a ventilator. She had been 2 days on the floor, unconscious in her condo, and brought into the hospital unconscious. And I looked at her advanced healthcare directive, and it said, don't have any extraordinary means to keep me alive. And I mentioned that to the ER doctor, and he said, her being on a ventilator, there's nothing extraordinary about that.
Right.
And so we had to have lots of discussions and to allow her to get her to remove the ventilator, to allow her to die peacefully. So it's one of the things is that people don't spend a lot of time talking about their medical care with their agents that they have chosen, because they just assume, you're part of my family, you will know what I want.
Well, my children will, but they're the exception.
Well,
but I do think that is the case.
There's a booklet called Your Way.
Yeah.
And you can get it on how to get it on our website under the materials page for this particular session. And I recommend it highly. It gives you multiple choices that you can go through with your agent, whomever you've chosen, and it gives different scenarios, i.e., I can't communicate with individuals, but I'm still conscious. What do you want me to do? Or I've been I can't communicate with people, and I've been this way for over 6 months. What do you want me to do? How do you feel about hospice? How do you feel about palliative care? Your agent needs to understand all this. The medical business is big business, and it's getting larger. The local hospitals today, Providence now has taken over from St. Joe's, and insurance companies are larger. So you need an advocate who understands your wishes, and they can keep you alive a lot longer than they used to. So you need to clearly state to your agent and have that conversation as to what would you like to do. And by the way, and it's okay to change your mind as you get older as to what you want. It's just that your agent is going to be speaking on your behalf, and your medical doctor or the hospitalist is going to check with your medical agent and ask them, well, how long have you spoken with her about her medical condition? They want to know whether or not you understand the issues, because else their wishes or your wishes is not going to be communicated properly.
Pete?
Yeah.
I've been having a wonderful communication with one of the attendees regarding this. And
Good.
And
why don't you share?
Well, that's what I'm doing right now.
Okay.
I mean, it's on the chat, or the question and answer. But she's got complete trust in her agent, and she doesn't have any problems leaving the decisions up to her agent. But she has sort of a concern. She says, if my children disagree with my agent's decision, would my healthcare directive overrule my children? What is, in that situation, what's the agent's role?
Ooh.
Yeah, I would say the healthcare directive would probably rule over the children. But there's, so here's sort of the reality of how that works. If how many of your kids were there? 5 kids, 6 kids, several kids, 2 kids? It sort of depends.
More than one.
More than one, right? Okay, so it's children. So more than one person.
2 children.
Okay, so 2 kids. Are they both local and actually going to walk into, like, let's just take COVID out of the world right now for a second, not pretend hypothesis, but 2 kids, and they're going to walk into the hospital room. But a different person is going to be the healthcare agent, right? So is that, and
Yeah,
okay.
Yeah, yes, there's one is a problem child and the other is wonderful.
Yeah, so but back to Jennifer's analysis, 2 of the kids come in to the emergency room and talk to the hospitalist or the ER doctor, and what's going to happen?
Right. Well, so here's I'll tell you what is going to happen, and then I'll tell you how you plan accordingly to prevent what is likely to happen. You walk in, you come into the hospital. If you can talk for yourself, they're going to listen to you. If you're able to communicate with the doctors or the staff in any way, shape, or form, they're going to take what you say, and at some point you'll say to them, and I have a healthcare directive, and that person is my agent. If that's the case, then they're going to listen to you completely, regardless of what your 2 children want or don't want. Your 2 children are going to have to run to court to be able to handle that issue if they want it handled differently, right? So you are there, you've communicated to the doctors, you have a healthcare agent, you've told them who your healthcare agent is, and it's not one of your children, right? They're going to listen to that person, and they're going to do what that person is addressing them to do, right? Because at the end of the day, everyone hates lawyers for a reason, right? Doctors especially, hospitals especially, they do not like the idea that someone is legally entitled to make choices for you, and then someone else is going to not handle that, regardless of what it is your children say. What they may very well do is say, well, and under the circumstances, here's the options. If those are long-term options, and someone, and the doctors are asking the healthcare agent and or the children are aware of what's going on, is this a long-term decision? Meaning, are you making a determination about them that could end up needing to be answered in 1 hour or in 10 days? And depending upon the length of time and how urgent that issue is, if it's 1 hour, then they're going to rely on the healthcare agent. If it's 10 days from now, I would imagine that those children are then going to go into court, get an attorney, go into court, and try and talk about getting a conservatorship over mom or dad or whoever it is that's in the hospital, to have a different decision made than the healthcare agent wants to make regarding mom.
Yeah, and that's why it's really important, if you're going to have a healthcare agent to sit down with them and document that particular time that you can with the Your Way booklet. It's not a legal document, by the way. That has nothing to do with legal. It just talks about your feelings of what you want. And having that authority, so to speak, that you're coming from a knowledge base that you know the person that you're caring for sways heavily with the nurses and the doctors at the hospital because they're used to having conflict within the family as to what to do. So they understand that. And it's exactly what Jennifer says. It's a 1 hour decision, or can they hold off making that decision for a longer period of time so that the matter can be settled?
Even so, just so you know, the idea is that there's a priority for the conservator under the law, and the nominations basically start with whoever it is that you've named as your agent in your durable power of healthcare directive. In any of those, that agent has priority to be the conservator of your person. So if a question ever comes to court, that person who's named in your healthcare directive first is the first person who has sort of a first right of refusal, kind of a claim to being your conservator, unless they can prove or show that it's not in your best interest to have that person be appointed as your conservator.
And when you pick an agent or a conservator, which you could name in your documents,
right?
Please understand that some people just can't do it. And so in my family situation, my mother was just the worst person to be named as a healthcare agent because she didn't understand doctors, couldn't stand blood, didn't want to go to the hospital. So, you know, her being my father's agent just didn't work out. And consequently, us children, when my father was in the hospital, we didn't have the power and we were in conflict. And so consequently, he was left on a ventilator until he died. So this stuff is very personal, and you don't want that to happen to you. You're in charge. You get to name that individual who's going to make decisions for you as to whether you live, whether you die, whether you stay in the hospital, whether you come home, who's going to be your caregiver, what kind of board and care you're going to have. This document is so powerful. It's all about your care, but the person you name, they're going to be in charge of making sure that happens. And I think we're running out of time. I'm not sure. How long do we have left there?
No, you still got 15 minutes. I have a question.
Sure.
Regarding, a lot of times this comes up in families, placement. You know, mom's getting old and demented, and you know the kids are fighting whether she should stay at home or we should place mom in a board and care or assisted living. Who has the authority ultimately as to that particular decision if mom has been declared incapacitated or can't make the decision herself?
So again, I don't like the term declared incapacitated because only a judge can declare someone incapacitated, right? That's just legally, you are presumed to have capacity and you get to make your own decisions until.
But what about doctors? Can doctors declare you?
No.
Okay.
They can give their medical opinion as to lacking capacity to handle financial affairs.
Not a declaration.
Yeah.
It doesn't matter, right? Like at the end of the day, you are a competent adult until the court takes away your privileges to act like that. And there's then a medical, capacity declaration and so forth.
Trevor, you have created the perfect tsunami because because now there's complete conflict. You have one individual who has the care capacity to name the facility, but now who's going to pay the facility?
Well, but I think so. Step back a little bit first. Let's answer those questions like as you would just walking through the issues. So
Okay.
nobody's actually declared incapacitated because this person is not a conservatee, right? So that's the more appropriate sort of scenario, because what happens is you have maybe had a doctor say, I don't think mom is in the place where she can make these decisions herself. I don't think she's at a point where she understands the nature and consequences, so forth, right? So at this point, we have kids who are trying to figure out what's supposed to happen. The two parts that need to be understood is, one, under the law and in general, everybody gets to make their own decisions until that privilege gets taken away. So mom gets to pick where she wants to live regardless, right? It's up to mom until it's not up to mom. Second is there's sort of under the law a presumption that people always want to stay in their home, right? So we call it the least restrictive. And the least restrictive needs to be in place when you do consider going to court and getting a conservatorship over someone, is where you want to put mom, and that's, I put it in quotes, right? Mom gets to stay where mom wants to, no matter what. That doesn't necessarily mean that's a good thing. It just means that that's the way it's supposed to work. Mom has the presumption and the ability to stay in her own home for as long as she possibly can, as long as she's able to take care of herself and do whatever. And even then, maybe not so much, right? So let's get to a point where at some point, mom then becomes unable to pay the rent on time and make sure that she's eating well, and now maybe is not bathing as often as she should. Maybe there's some issues there in terms of she's not able to really handle her money aspects and or her personal care, and she's in her home. So then the question is, who on those two children, right? Is there a power of attorney? Is there health care? At that point, if there's a power of attorney, and let's make son the person in charge of the money, and let's make daughter the person in charge of the person, right? So daughter is the agent for healthcare, son is the agent under the power of attorney for durable power of attorney for finances. So what if daughter, to Peter's point before, what if daughter wants to put mom into a, smaller board and care where there's, a handful of people, and she's going to be what she believes to be more and better cared for, and in a more nurturing home-like environment that would be nice for mom, but it's more expensive than the assisted living 70 miles away that son has found for a bargain basement price of, whatever. So who gets to make that decision? Right. And the reality is that under those circumstances, it would be a hard decision to make. And when the two of them were at odds like that and they couldn't agree, one of them would eventually end up going to court and filing a conservatorship so that they could be in charge of that placement. And under that healthcare directive, if that healthcare directive also was a nomination for a conservator, daughter would have priority to be the conservator of the person for mom. And under a conservator of the person, that's who would decide where mom was appropriately living.
So the bottom line is, make sure when you're putting these documents together that, again, that who you name is really important. Do they get along with the other kids? Are they a good communicator? Can they follow through on what you are asking them to do? Religiously, can they follow through? So many issues that you kind of need to consider. And if you're going to name different people in different positions, like I see usually the finance and the care, make sure those two individuals get along and can communicate with one another.
Or make sure you're asking your attorney to draft them so it doesn't matter, right? So
who has priority?
Right. So what could happen under that circumstance is that maybe it says under the healthcare directive, I want my healthcare agent to be able to determine where it is that I go and stay, and be able to use the resources from my money side at their discretion, then there's nothing that would stop them, and they wouldn't necessarily have to go and get a conservatorship to make that happen.
Yeah, as a professional fiduciary, I will not serve as an agent for somebody's health care unless I am serving in the other powers, because I don't want to get into a situation where I think what is best for a particular client and then don't have the resources or the monies to spend it. Because in reality, sometimes when you're spending money on the client, you're reducing the inheritance of the children. So it's a little bit of a conflict.
I do try and tell people, and I say this mostly to anyone, of any reasonable age down, it's an expectation of an inheritance. Stop thinking of it as an expectation, right? It is very irritating to me to see how people imagine how they are entitled to someone else's anything, much less feel as though they have already been able to take it on to the point where it shouldn't even be spent by the actual person.
Yeah, it's one of the reasons why we call the program It's Your Estate. It's not your children's estate. It's not your attorney's estate. It's not your spouse's estate. Each one of us have to take responsibility for ourselves. And one of these responsibilities is our death. How do we want to die? We get to choose. And by the way, most of us are going to die in our sleep. So, but there's a good large number of us that are going to suffer some type of mental disability as we get older, and we need assistance and help. The good news is we get to choose who that person is while we're alive. And we can, just like a good employer, we can quiz them, we can ask them questions. What would you do here? What would you do there? And we've got plenty of assistance that will help you. But not making a decision is the worst. Talk a little bit about what a conservatorship cost just on the estate and the person's side if there are no conflicts.
If there are no conflicts? Wow, do those actually exist? They don't in my world. So
you're kind of like the cop on the beat. I mean, you see the worst of the worst.
Yeah, it really is. And I tend to only get the kind that escalate from other attorneys, turning them over, because there's either attorneys who do the paperwork if it's absolutely nothing else and there's no one in the world to contest.
Yes.
Those probably will run you. I mean, it's $575, I think it is now, to file it. Right, whatever it is for a document.
I think it's around $10,000 if there's no problem.
I would say somewhere around $7,500-ish or so if there's absolutely no fighting whatsoever and nobody's doing anything.
But if there's a fight, it can
If anyone is breathing, there's probably going to be a fight. If there's any siblings, there's probably going to be a fight. If there's ever been any kind of moment where any of your children have ever disagreed about absolutely anything ever, meaning the color of, the wall or the kind of pie that's their favorite, they will fight.
Jennifer, if anyone has a particular question about some of the things that we discussed or have a litigation concern about their estate plan, could they email you or call you as a follow-up to our today's session?
Sure.
Okay.
I can't give legal advice to non-clients, but I can absolutely tell you how things generally work. And it's not specific legal advice, but I'm happy to answer any and all kinds of legal questions, general information, how processes work, any of those kinds of things, for sure.
It's been very interesting having you give this session, because this is the first time that we've had an attorney who's primary a litigator talk about some of the issues that come up in the advanced healthcare document and also in the power of attorney document. So, Trevor, do we have any questions out there that we need to address?
Oh, yeah. No, but they've asked me to put her
Contact information up?
yeah.
Okay,
Sorry.
just remember all of our material and the Ask First form and the outline is on our website. And the easy way to go about getting there is iyme.org.
Yeah. Yeah, no, that was Jennifer, it was very interesting hearing from your perspective these sort of situations. Often we just have planners, and it's left to us fiduciaries to kind of do the scenarios. But it's also very admirable that you are volunteering and helping people in the community through FAST and all these other through the
In fact,
council.
let's take a second out because they're not sponsors, but it's a very important nonprofit in the community. And that is the not just FAST, but the
Council on Aging.
Yeah, thank you. The Council on Aging here in Orange County have a number of different programs. They have HICAP, which will help you out in long-term care issues and policies. They have Medicare information. If you are in a financial abuse situation, they have a program called FAST, and Jennifer is a volunteer as part of that program. The council
just for something like that, we volunteer and we do what we do, but we also volunteer to answer questions for people that have, particular issues. They can call us through FAST and they'll refer us over. I actually did a conservatorship case through FAST pro bono a couple of weeks back, and I guess it's been a couple of months, and it was just the most bizarre thing in the world. But the city of Newport was trying to conserve this woman, and none of us believed it was possible because that doesn't happen. So we just assumed this was a crazy person calling and almost never called her back. But in the end, it was true, and we were able to help make that go away for her.
Yeah, and you may not need him yourself, but maybe you have a friend or acquaintance. The Council on Aging, they also run an ombudsman program for all the board and cares in the community. So they're just a Council on Aging, and it's just an excellent resource. And they also do volunteer work at many of the community centers and senior centers in Orange County. Council on Aging.
Hang on. They wanted me to share that too real quick. This is the website. If you wanted to, and then you can follow it. It's just Council on a COASC, which stands for Southern California.org. And then if you go through here's the programs, and they have all the programs there. Yeah, the HICAP, the Ombudsman, FAST, all of these different programs. So it's cool. Okay. All right, then let me stop share. Okay, and thank you. Pete, quickly, next week we'll be going into the Living Trust. Give us a little preview as to what we will expect.
What we're going to do is that we'll focus entirely on the Living Trust area. We'll go through what a typical Living Trust has. We'll especially focus in on the trustee and distributions sections. It's a great idea to have your Living Trust with you, and so you can kind of go through it with us. Most times people don't ask the questions because they're in front of an attorney and the hourly rate is going on. So this is the opportunity to ask away of what different sections of the trust means. So we'll spend an hour and a half discussing a living trust. And Jennifer, thank you so much for being here today.
My pleasure. My pleasure. You guys have a great day. Thank you so
All right.
much.
Thank you so much, and thank you, everyone. Have a great weekend.